Thank you. Hi, good evening. This is my name is Jeffrey Mullen. I'm the acting chair of the panel of the Comprehensive Permit 582 Blue Hill Avenue. Today is November 10th. It's 7 o'clock p.m. With me is Frank O'Brien and Giselle Joffer, members of the board, and we're joined by Judy Barrett of Barrett Planning Group and Tim Zawinski of the town planner of the town of Milton. So just to catch people up on where we are, I want to make an introductory statement. I'm going to turn the meeting over to Ms. Barrett, and she can guide us through these next steps. I think last time I acknowledged and thanked everybody for their work in getting us to where we are. So thank you for that. But people will recall we did close the public hearing the last time and no longer taking testimony. And our task 2 weeks ago was to review the draft conditions that Ms. Barrett has prepared, review the comments on the draft conditions that we received, and I'll publicly thank people for receiving them. I've got Mr. Hill's printed out here and been through them. And of course, the applicant has commented on them. So for that, we're thankful. Let's acknowledge other feedback we've gotten from town officials. So thank you all for that. I've been through the conditions and let me make four comments before I open it up to the members and then ask Ms. Barrett. The first is I think they're good. I think they're a fairly comprehensive expression of the 11-month hearing in which we've engaged. The second is a lot of my comments were in the nature of sharpening the defined terms. So we've got approved plans, capital A, capital P, which are the plans that have been submitted to the board. And then we've got final construction plans, capital F, capital C, capital P, which are the plans that would be developed by the applicant consistent with the approved plans for the purpose of constructing the project, capital P, on the project site, capital P, capital S. So, I mean, that's a lot of the comments are just that, just to be consistent with the use of those terms. The reason why I think those terms are important is I don't think, at least it's my view, that the condition not repeat things that are in the plans. So for example, I don't want to get into the detail of the signage that's on the plans. Mm-hmm. They're on the plans. The project has to comply with the approved plans. And we need to trust the building commissioner, the city engineer, and the DPW director to enforce those plans consistent with the comprehensive permit that's being granted. I think if we get away from that model, the permit just gets unwieldy. So let me just make that statement. The last thing I want to say is there are a couple things in there that I didn't see that I'd like to see. There could have been oversight, but I think we should talk about them. Like, for example, I'd really like to see the applicant work with the MBTA to create a bus stop here. I don't think we can mandate that because that's an independent activity that requires a third party. But I think a bus stop on 138 is the kind of thing that we ought to be striving for to try to help the mode shift problem that this project suffers from. That's been universally acknowledged. The bus goes down there and stops anyway when it gets flagged. I know there are a lot of rules on bus stops, but I think that's the kind of thing that I didn't see in there that I'd like to see. I mean, another thing is to make sure that the treatment of the cross section of Blue Hill Avenue and any of the work outside of that wall is consistent with MassDOT's plans for the state highway. So, I mean, I think those have been acknowledged in the planning exercise, but there's a couple of things I didn't see that I'd like to see. So that's a long way of saying kind of where we are catching everybody up. What I'm proposing to do, I'd like to ask Mr. O'Brien and Ms. Joffer if they've got initial comments along the lines of what I've said. and then really turn it over to Ms. Barrett. She's got this a red line that she'd like to run through with us. I don't know that we need to wordsmith every word. We can look at this again, but this is a sense of the board. What do you think? Is this right? Is this wrong? Because otherwise, I think we'll be here for several hours, and I'm not like you folks, but I don't really like you that much. Maybe I should say it a different way. We've spent a lot of good quality time together over the last year. So that's what I have to say. Ms. Joffer, I don't know if you want to make any preliminary comments.
I don't. I think I did last time. So
Yeah,
those were my initial reactions. So thank you.
you're welcome, Frank.
Mr. Chairman, I agree with you. I started to go through this and then I literally took a step back from my desk because I felt like I was wordsmithing, and I when I look back at some of the stuff I had worked on, I was basically saying the same thing that Ms. Barrett was saying. And one of the things that I have learned through my career is defer to the experts until you decide that you don't want to defer to the experts. So at this particular point in time, Ms. Barrett's been through this. I'm basically good at a 10,000 foot level with the direction that these conditions are going in. There could be some details and whatnot. I think that Giselle at the last hearing laid out a few additional three or four of which I had on my list. I think your comment here, and I will defer to you as the expert on transportation matters, but your point regarding enhancing the MBTA is well put. The only other thing is that I think as we get to it, there are certain things, particularly in the drainage side of things, that I think we're going to have to spend a little time with in order to make sure that we're where we think we're at, if you will. And I'm particularly mindful of some of the down the hill impacts on one abutter in particular. And there were certain representations made. I want to make sure that we have accurately and fully, and that we're all on board, because fully on board on what is written and what is meant by all of those. So kind of as is typical of me, kind of a long-winded way to answer your question, but thank you for asking.
You're welcome. You're welcome. Mr. Zawinski, do you have something you want to add at this time?
Not at the moment, sir. I think you all captured it pretty well. There are probably some detailed specific things as we go through the draft that we'll want to talk about and take a look at. But I think, as usual, Ms. Barrett has done a really good job of synthesizing and compiling a lot of what we've talked about over the past few months. So looking forward to getting into it.
Yeah, one thing for you, Tim, to think about, there's a couple of places where I wasn't sure whether or not it was a town engineer's responsibility or the DPW director's responsibility. And then, of course, we've got kind of overall jurisdiction of the building inspector. So to me, those are the three, instead of saying approval by the town, I think it might be a good idea to get in the habit of specific people, so there's not a question of what the town means, especially given our form of government. So, but I don't know enough about town government to know which of those three individuals it is. So that's something I think you maybe don't have to focus on tonight, but I think as we finalize this document, that is something that will require the town's attention.
Yeah, Mr. Chair, to that point, the last approval that we worked on together at the Ice House property, we had actually walked through that, myself, Judy, and Joe Prondak, the building commissioner. And he identified a couple points, similar to what you're referring to, where there were references to either the town or the board, And he expressed the desire for a little more clarity. The Board of Appeals is, this is your permit, but ultimately, it's going to be the building commissioner sort of is the eyes on the ground and the guy getting his hands dirty on this stuff. So I think it's a good instinct, and I think that'll be helpful as we go through this.
Okay, great. Ms. Barrett.
So thank you all. I owe the board a huge apology. I had hoped to get this out sooner. It just wasn't going to happen this week. So thanks to a very able person in this office, Catherine went through and tried to incorporate everything that Jeff had given us, and also some earlier comments from Sean Reardon that I hadn't had a chance to bring in. And Tim had given me some comments from Chase. Those are in here now. So this red line is kind of messy, like red lines tend to be, but I think I can kind of just, if I could screen share this and maybe we could go through a couple of points. I absolutely promise you the next version of this will be cleaned up. I've left the footnotes in that were in the previous version just because there were things that like Attorney Hill or Attorney Schomer had said that I had not integrated. I wanted the board to be aware of those things. But I think once we have a comfort level with this, I'd like to get those footnotes out of here and just make them go away, because that's part of what's elongating this document and making it look like a book. But I think with that said, I'm just going to go ahead and screen share, assuming I have permission to do so. So who is the host this evening? Who can give me permission to screen share?
I think I can do that, Judy. Hold on.
Oh, okay, thank you.
Share all panelists. You should be all set, Judy.
Okay. Ah, very good. Thank you. Can you see this?
Yes.
Okay. I always get very timid with screen share. I'm never quite sure that people can see what I want them to see. So this, as I said, is kind of messy, but you'll see just a series of margin notes where Catherine kind of entered stuff that she had been given. I don't think these initial general conditions need a whole lot of discussion. I went through the plans again because I realized that one of my questions I didn't have an answer to, and I felt stupid, but it was just the bedroom count on the number of units. And if the board doesn't care to specify that, I would just take it out. But if you want to lock them into a particular bedroom configuration, I'm pretty sure this is what it is.
Well, I have a comment on that. I think that should be, I like the breakdown because it highlights, probably the key or certainly a key issue for this permit. And I know it goes against my my recently adopted rule of not repeating what's in the plans. I think it should say the project shall consist of no more than 84 residential units consistent with the approved plans in the following configuration, something like that. I mean, the plans do show the breakdown of the units. So something like that. And I'd only call them out because it seems to me that it's just a fundamental something, and somebody like Mr. Dennehy, for example, or a member of the board, select board, might want to know and might not have the time to get into the plan. So that's point one. But I also want to acknowledge that this was one of the few conditions that Mr. Hill completely disagreed with. And I want to acknowledge that we're aware that he disagreed with it. So, he's given us a markup of the document, and this was one. Bose Hill Associates Inc. does not agree with this condition, period. It goes on for several more paragraphs, but I at least want to acknowledge that that we're aware of that, and that there's disagreement on that pretty fundamental point. Others?
Can you remind me, Jeff? Was he proposing fewer units?
Yeah. He wants a less dense number of units, but also, make specific reference to modifying the north building, modifying the garage in the west building, and the 75% open space requirement. So, I mean, it's a fundamental point, and I think Rose Hill neighborhood is just going on the record saying that they continue to believe the project is too dense, consistent with the testimony that we heard.
Mhm.
You know, I wasn't surprised by the comment. I just think it's, people took the time to go through it in a thoughtful way. I think I wanted to acknowledge that it was similarly thoughtful of the board, and I feel like that issue was pretty adequately addressed in the hearing, and the peer reviewers specifically addressed that point, both of the key peer reviewers, Mr. Bulmer and Mr. Reardon. And that was backed up by the DPW director. So that's at least my sense of it.
Yeah, I mean, my understanding of Mr. Bomer's testimony was that ultimately he came to support the final design, which he thought had come a long way in
Yeah.
terms of, the number of units and the density.
You're referring to Cliff Bomer, Giselle?
Yes,
Yeah,
am.
he did. Yes, that is true.
These things always come down, not always, these things often come down to, if you will, the debate between art and science. And reasonable people can disagree regarding architectural related stuff, if you
Mhm.
will. And I'm not denigrating Mr. Hill, the Bosu's neighborhood's concerns by calling them mere architectural disagreements. But there were some fundamental disagreements on how this thing should look, how dense it should be, how big it should be, and that sort of thing. The science, if you will, on this came down to, is the infrastructure that needs to be put in place for the architecture to work, is that going to be adequate for the density of this particular proposal to work? And at the end of the day, 2 out of 3 of the people who testified on those particular issues essentially agreed that it would work.
Yeah.
Whether they're right or wrong is to be determined, but at the end of the day, it would seem to me that I'm not going to go so far as to say as a matter of law, but almost as a matter of law, you could make the argument that there's substantial evidence in the record that would allow something of this size to go through just from the practical engineering aspects of it. Does it take it out to as far as it could go? Probably. Are there legitimate design and other objections? Yes, but based on the record, the engineering is there to support something this size. So if the engineering is there to support something this size, on what basis would the board have to reduce something?
That's the key question.
I mean, I will, in all honesty, I'm not thrilled with the size of this thing. I'm really am not. But on the other hand, I struggle with, after reading the cases and looking at, after reading the cases and reading the literature and whatnot on, I struggle with what's the legal basis for the board to be able to reduce this. And if the board decided to reduce it, do we run afoul of, would that decision stand up? And on what basis do we make that decision?
So, you would want technical support on the record that the local concern of size or scale outweighs the regional need for affordable housing. I mean, that's the central finding in 40B. That's the balancing test. So, what's the evidence? Because the evidence on the regional need side kind of stands on its own. The town is not at 10%. So that's how the sort of 40B decisions get made. It's this kind of balancing. You have a local concern about scale and design. And I'm not saying that's illegitimate. I'm just saying that is a local concern. That's actually recognized in the statute that design, site and building design are legitimate local concerns. So now the question is, what's in the record that's technically supportable that would say there are issues in that local concern that outweigh the regional need? And that's where I get stuck, because if you, my tendency is to go with what the peer reviewers say because they're your advisors. Anybody else on the developer side or the neighborhood side is speaking from an advocacy position. I think we all understand that. So it's the peer review consultants and of course the town departments too, that are the most neutral parties, if you will, advising the board. That's kind of the way the process is set up. So I would look to the peer review reports to say, is there a technical basis to say it's too big?
And
Aside
in
from the
doing,
optics of it.
yeah, I mean, and in doing that, after reviewing my notes and going through the things that are in the record, I'm not finding a technical basis to rule that it is too big,
Right.
particularly in light of the fact that the applicant has, through the course of the process, and the applicant could potentially argue that the process has worked because at one point in time, the project was larger than it is now.
Right.
It has been now reduced by X%. So if there's no evidence to support a further reduction, other than the evidence put in place by the Voles Hill Neighborhood Association.
Well,
So,
Carol Tagayas did on June 23rd, according to my notes, recommend 14 less units. In the timeline, I don't know if units were actually subtracted in all these different iterations after she testified, but that is, she did sort of specifically, she was one of the few advisors or commentators who, was specific about numbers and said, look here.
And I don't remember where her testimony falls in that sequence either, Giselle. I'd have to go back and look. I do remember that she said that.
Yeah, she says lose 4 units on the north, lose 10 units on the garden side.
Yeah.
And the loss of 14 units would improve intensity of use.
well, I think that anybody can argue that reducing the number of units would reduce the intensity of use. One follows the other, but
Right.
by 14.
Yeah, I mean, I'm not sure. She's an
Yeah,
architect,
neither am
right?
I.
So I think that was just her professional view and review of the plans at that time.
I think the record's pretty clear that, while we are relying on the peer reviewers, as Judy said, the peer reviewers did consider the advocate's position in coming to their conclusion, and there was a fair bit of rebuttal back and forth and a resolution of comments, including the comments from the planning board and Mr. Tagayas. So I feel like that issue was very well vetted. I think the timeline, some of the units had already been dropped from the original configuration by the time the planning board testified, because they testified pretty late in the hearing. I don't think there can be any question that the record reflects that the peer reviewers did consider the advocate's position and considered lowering the units, but felt like the site could handle it and that there was appropriate controls on the property to manage that kind of density. So I think that's a fair summary of the record.
Yeah, I mean, I don't disagree. I think it's difficult to track Cliff Bomer's testimony, which was careful and detailed and sort of specific to the plan at hand, and come out otherwise. I just wanted to point out that, there is support in the record for a reduction.
Yeah, no, I agree. And there was the advocates consultants were also they were both professional and credentialed and are experts in their own right. We just happen to have peer reviewers who disagreed, I think, in some fundamental ways. But my point is that it wasn't that they were completely disregarded. It was
Right.
considered and other judgments were made, I do think the word approximately in A4 should be removed. We're either going to say, to me, that's what the plans reflect. And it's a helpful data point because that's an important thing. That's my only recommendation, other than wanting to acknowledge that what the Vos Hills neighborhood has put out there.
And that's fine. Jeff, I think I just want to go through the floor plans one more time and make sure I've done an accurate count, but I'm taking it right off the plans. So
Yeah.
I'm happy to take approximately out. That's fine. I don't care.
Yeah, I mean, I suppose there's always an opportunity to come back and modify the plans, but we're either approving the plans or we're not. And the plans show this number of units in this configuration. That's what the applicant has asked for. And we're ascribing conditions to which we agree that if you build this number of units, you have to make these conditions to mitigate the impacts. Okay, fair enough. Go ahead, Judy.
So, a lot of this kind of red line or insertion is from comments either from Jeff or from Chase or from Sean Reardon, or material that came from Jesse Schomer or Dan Hill by the deadline that had been set by the chair. Some of the changes that the applicant's attorney had suggested. I'm sorry, Frank,
I'm sorry, Judy, I do have a question, and it's kind of a basic one.
Okay.
If you wouldn't mind going up just to the to page 1. There's a phrase there. And I just want to raise this with my colleagues, and this is just a little bit of local practice, if you will.
Mm-hmm.
You use the phrase in A5, but generally consistent with approved plans. I just want to touch bases with my fellow board members, because typically in the decisions that we write for your normal run-of-the-mill deck or garage or what have you, we use the phrase in substantial conformity with the approved plans. And I just wanted to touch bases with my fellow board members regarding whether that should be the phrase used instead of what was in there, because it's local practice.
That's fine.
It's also used in A2,
Oh,
substantially in conformance with. So,
well, why don't I just,
listen.
I can fix this easily.
That's my error. For the record, that's my error, because that's my edit.
Oh, it is.
I think Frank is right. I should know that. We've done that enough times. It's been a lot of decades.
I just don't want the building inspector to have a question in his mind. Is this different from what I do consistently in the course of my duties?
Yeah, no, it's a good point. Yeah.
Okay. Thank you. Shall I go on then?
Please.
Okay.
Thank you.
Some of the red line in here really is insignificant, and I'm not going to spend a lot of time on it because frankly it would drive you guys crazy. But I typically say in the decisions I write that there's a chain of communication with the town that occurs if there are going to be communications between the applicant, other permits outside the town, various approvals with state agencies or others, that the board always gets copied and the building inspector gets copied. So you have a paper trail. The applicant is suggesting, and this was in the comments that he gave to the board, before the deadline that had been set, that this condition could be accomplished with a lesser burden on the applicant, with a minor change requiring the applicant to keep the board reasonably apprised of such matters. I don't know how specific you want to be here. what I wrote here is typically what I say. I'm not married to it. It's typically what other boards I've worked with want to see, but I need some guidance here on what your style is on this. I mean, there could be lots of communication or not that much. I just don't know.
Let me ask, I don't know the answer, and I don't know if anybody on the board knows the answer. There's two points I would make.
Mhm.
First, to a certain extent, this is a policy call on how the town is going to manage the 40B process. So that's point one. Point two is, I think it's a question for Tim to
Okay.
talk to Mr. Prondak about. I mean, I think, the board, we're a bunch of volunteers. We're never going to see any of this correspondence. And the building inspector is housed in the office of the Board of Appeals. So nobody is asking the applicant to be overburdened. At the same time, I'd be interested in what the building inspector feels he needs in order to enforce the provisions in his permit. To me, that's the real issue. And, getting copied on correspondence is one way that he can keep apprised of what will certainly be an important project to the town. If he has another way to do that, I would be willing to listen to that, but I'd like to get his impact before we made the decision on, recommendation on what to go back to him. That's my sense.
That's fine. I mean, Tim and I can talk. You can
Yeah.
check with the building. The building inspector was really helpful going through the Ice House decision
Yeah,
and gave
great.
me some very helpful comments. So
Experienced guy.
yeah, he was great.
Fine line, these things tend to be controversial, and controversial stuff,
Yeah,
it tends to be better to over communicate than under communicate,
Agree with that
but
too.
it's a small department.
well, why don't I talk to Tim, and Tim can, or one of us can talk to the building inspector, see what he thinks, and I can just, when I send this back to you, I can just add a note and you can decide.
And then secondly, Judy, I think we should be consistent on this point with the
Yeah.
40Bs. I don't want any unfair point on that is, let's treat all the applicants the same.
Okay, so just on that note, I think this very condition is written this way in the Ice House
There
decision.
you go. There you go. Now, it could be a reason for doing things differently. I don't know, but,
Well, at least if you're gonna do things differently, know why. You know,
Correct.
I'm not trying to tie anybody's hands. I just want you to know. Again, a lot of this is helpful, picky comments from Jeff, form, references to, so that I don't have to repeat things. I don't think you need to go
Hey,
through.
Judy, I do this for a living, okay?
I know, and I appreciate it. Are you kidding? I told you, I always learn from you guys. I have no problem with any of the comments you made. There was something here, though. You had wanted a definition of, I referred to the DHCD guidelines. Now, I don't want to take you down a rabbit hole with this, but the DHCD guidelines are not really they do have an identity in that the regulations authorize DHCD to adopt guidelines. So I have inserted here the title of that document, but I can't tell you that will always be the title of that document, because it could change at midnight some night and nobody will ever know, because it's not subject to, the same standards that regulations are. It's a policy document, but that is what we're referring to, because a lot of things are in the guidelines. So
Yeah.
I just put the whole title in here, and then I said, guidelines in quotation marks for future reference. It's the best I can do.
Yeah. I mean, there's ways to adjust that, but I think that's helpful.
Okay,
I also draft stuff for a living, and I draft a lot of statutes. So let me ask you a question. Is it necessary to identify the guidelines as they exist at a particular point in time? Or is it necessary to add language in there that as they may be amended from time to time?
Yeah, that's. the
I
way to do
don't
it.
know.
I can do that. I intentionally didn't put the date in here because I'm telling you, these things can change at midnight with no notice.
Well,
So
that's my point. And my question to you is, how important is it in this decision to cite to the guidelines at a particular point in time, or is there a risk, and how big of a risk, of the guidelines changing and then changing something fundamental in the decision?
Well, the guidelines can't exceed the regulations. They interpret the regulations.
Yeah,
So-
but that's in the eyes of the beholder.
I understand. I mean, people do not realize what isn't in the statute and isn't in the regulations. People have no idea. The very fact that 100% of the units are counted in a rental development is a policy that's just kind of out there. It's not in the law. It's not in the regulations. It could change tomorrow. I'm sure if DHCD was on this, they'd probably slap me for saying this, but it's the truth. So a lot of this is just practice.
I think
But-
here, I think the way, what this is going at, and
Yeah,
I think this term might be used elsewhere too.
okay.
In this particular sentence, it's going at affordable units, so it should say then in effect. Subsidized housing inventory then in effect, or something like that. And that implies that you could, I would do it before the parenthetical there, after the word subsidized housing inventory, you could say then in effect. And that addresses Frank's point. It also implies that they can be revised. But the idea of how to establish the AMI and therefore what is an affordable unit is going to be established at a particular moment in time.
It's true.
And so it's got to be the guidelines that are then in effect.
Agreed. All that gets wrapped into the regulatory agreement, so, which fortunately you guys don't have to worry about. A lot
I
of
have
this. again- I'm sorry.
Basic question about how you calculate who qualifies.
Yep.
So I understand what area median income would be as a mathematical matter. What does it mean to be below 80% of area median income?
It's basically the HUD income limits, which DHCD adopts as a matter of course through their regulations and in the guidelines. HUD
And-
sets the income limits, so 80% of median is the maximum that's allowed.
So Judy, can I jump in here?
Sure.
I have a very basic knowledge of this, and so I think it's a basic question. So Giselle, it's math, right? So if
Yeah.
$100,000 is the median income, that's 100% of median.
Mhm.
So 80% of median income would be $80,000. And so there are, and this will be in the regulatory agreement and the Affordable Fair Housing Marketing Plan and all of this, there are income certification procedures that DHCD has that the management company for the property will need to evaluate applicants based on. So, they check, your tax records and your assets and everything to make sure that in order to be eligible for the lottery where these units get distributed, that you are not making beyond, I use $100,000 as 100% of area median. It's different it's a much less round number. But sort of they use that so that if you're making more than that, you're not considered to be, you're not eligible for a deed restricted affordable unit. There are other programs that use the 60% AMI figure, the 30% AMI figure for deeply affordable units. But as Judy said, these are all kind of generated by HUD, and then DHCD kind of piggybacks onto those for the ease, as it were. Does that make sense?
It does make sense. I think I was just grammatically reading it wrong. I thought it was saying at area median income or below 80%, and that was confusing, but it's at or below the 80%.
Yes.
Got it.
Hey,
So I
Judy.
Thank you, Tim. That was helpful.
Yeah, he explained it better than I do, and I've been doing this for 30 years, so I'm embarrassed. Anyway,
No, but the numbers helped.
pardon me?
I said, you explained it well, but the numbers helped. I was overcomplicating it.
That's fine. So again, a lot of this is it's just entering the comments from Jeff. Typically, some of these may have been from town staff or Sean. I mean, I'm just looking for something I think you really want to see. And I don't think, so this whole section on submission requirements is about what does the applicant have to do before they qualify for a building permit, before they get to touch the site, before they get a certificate of occupancy, There are just a series of things that they have to do in order to qualify. So this is really important for the building inspector, this whole section, because it's really going to determine when he can hand a piece of paper to the applicant and say, go forth and build. Most of these are really pretty standard. It's about, making sure the building inspector knows who to call if something happens, if there's a problem.
Judy,
Yes.
on this section, can you back up on C1?
Sure, of course.
C1. So in terms of what to do before construction activities, there was a request to notify the neighbors.
Mhm.
What is customary?
Well, I've not seen that done, but I'm not saying it can't be done. I mean, typically it's, I often fall back to what would you be able to require if this were not a 40B? Because bear in mind, that's kind of a fundamental principle, is that you can't impose on a 40B things that you can't impose on some other project.
Yeah. That's a hard question for us who've sat on lots of hearings over a long period of time.
Yeah.
We've never had a hearing for an 84 unit apartment complex in
I understand.
Milton, so
Yep.
I don't know what's customary. I think it's a good question for the building inspector and whether or not he thinks it's reasonable for people to know just some advance and say, hey, okay, we're about to start this pretty big and important project. So, I mean, that's really where I come down on it. I agree with you. I don't think it's unreasonable. I don't know that it's appropriate, and I don't want, this is not about adding burden, but to Frank's point, notice is good. Project is important.
Yeah, I don't see a problem with it. I guess my caveat to you is always going to be to stay on that side of the line of what's jurisdictional to the board. That's all.
Yeah.
You know what, there's burden and then there's burden. And that.
Capital B.
Yeah, I mean, this kind of requirement would seem to me to be a good neighbor burden. And
Mhm.
how is that different from requiring such things as dust control or, other things that reduce nuisances?
Well,
during the
they're
course
going to
of
have to do that anyway. Those kinds of things they have to do. The question is, do they have to tell the neighborhood they're doing it? That's, I think, the issue is just what is the notification responsibility of the applicant? If the board feels that neighborhood notification is important, I mean, I'm happy to put it in here. I just caution you to bear in mind that sort of principle of what can you impose on any other type of project.
Just so
Judy, I
we're
don't-
clear about what we're talking about, this is notification that the construction is about to start. Is that
Yeah.
right?
Yeah.
This is
Yeah.
actually before the building permit. This is just, I'm going to do something on the site.
I think the request was prior to construction.
Yeah,
14
that's what I
days.
thought.
And that's the section we're in, is
Yeah.
prior to any site construction, with or without a building permit.
Yeah, so it's the way this thing is loaded is anticipated that there's going to be some pre-building permit activities.
Mhm.
So might not have a building permit to do some of this work, I don't know, but the idea is when you get out there, you'd have it notified. The request was for 2 weeks.
Mhm.
I think it's reasonable. I think you should confirm that with the building inspector though,
Mhm.
or Tim can.
Yeah. That's fine. I wrote a note to myself. We'll do that.
I think it's reasonable too.
And
That's fine.
just in terms of the burden, I mean, I think a general notice, I'm not talking about something that you don't have to, the notice doesn't have to be sent every single time a cement truck shows up
Sure.
or what have you, but a general notice that, hey, we're going to get started on or around such and such a date is de minimis.
Right.
Yeah.
That's fine. Let me talk to the building inspector. I'll ask Tim too, and we'll report back.
Thank you.
That was my
Yeah,
thought.
for what it's worth, the planning board often includes conditions similar to this in their special permit and subdivision approvals. A lot of times it kind of takes the form of, we've got a list of interested parties that have participated in the public hearing. and those folks kind of sign on to an email update list or something like that.
Oh,
Um,
fine.
And I know, in City of Boston, one of the things that we typically did on these larger projects was, a lot of times these projects have a website, that will wind up being sort of the marketing website, but during the construction period can kind of serve as a kind of one-stop shop for, everything going on with the project.
Of course, that's
That's a great
Boston.
idea.
Yeah.
A portal, an internet portal
Yeah.
for communications.
Mhm. I think that's fine. I mean, you have to be able to kind of sculpt this in the way that you're going to be comfortable, given the scale of the project and, all the concern in the neighborhood. I don't have any issue with this. I think Tim's point is well taken. If the planning board's already doing something like this, what's the harm?
And I have a question, actually. This just occurred to me. Is there a mechanism for communications in the other direction?
In what way?
Let's say I'm a neighbor and I have a particular complaint about something that's going on in the construction process.
Well, typically
Yeah.
that would go to the building inspector.
Okay. Just wondering, I'm just sort of thinking of the neighbor analogy, right? That Frank drew. If my neighbor is doing construction, I'd just sort of reach out to them and be like, oh, FYI, the mud's draining onto my property. I don't know.
There's also a little bit of a difference, if you will. I think that there would be at least a supposition or a presumption that this is a sophisticated builder who should be aware of the rules,
Mhm.
as opposed to your neighbor who perhaps starts at 7 a.m. on a Sunday when he or she really shouldn't be banging nails at 7 a.m. So
Or running a leaf
your
blower.
point is well taken, Giselle.
That's fine. I'll work on some language for that. I think that's fine. Let's see. Again, a lot of this is, editorial precision that was very much appreciated. I'm looking.
Judy, where did the 20 grand come from?
I think Sean. I actually had that in the previous decision, the previous version of this. Pretty sure it was Sean. I'll verify that. I can go back through my notes. Did you have a concern about the number or?
That's the kind of thing that I would, I didn't have a comment on it except to say I would want the technical people to give us that number,
Okay,
whatever's appropriate for the things that it's securing
okay.
and not just made up.
I'll verify that.
I'm not suggesting it's made up.
Yeah, no, I understand. I came from somewhere because I originally had a blank.
It's
And
two
where my-
times what was Vos Hill asked for.
Okay,
I don't know if there are I don't recall if there are surety provisions in here, but if there's the same sort of thing should be applicable to anything that requires a surety amount.
Yeah.
okay. Surety, next paragraph. It's H here at the top of the page. Do you want me to blow this up or can you see it?
No, I can see it.
Okay. Whoops. I wasn't sure what I had the Zoom set to. I'm pretty sure this language came from Sean.
Yeah, I would just have the either the DPW director or the building inspector specifically focus on that.
Okay,
I feel like collateral, big picture collateral or security was a theme of this hearing.
Mhm.
Along the lines of what assurances do we have that the applicant will do what the approved plans require that it do, and what do we have as a remedy in the event that they don't? So
Mhm.
we're gonna for that, I'd like to rely on the people who are most responsible for enforcing the requirements of this permit.
So I have a question regarding this particular language. The
Yes.
surety shall be released by the board upon permanent stabilization of all surfaces and installation acceptance of all drainage infrastructure. Who accepts all drainage infrastructure and whatnot, and how is the board to be made aware of that so that the board can make a determination regarding whether or not to release the bond?
Well, in other towns I work in, it's the consulting engineer who provides that by memo to the board.
So my question would be, is that standard practice? Or, I mean, just looking at this particular language, without any context, I wouldn't come to that conclusion unless I was an expert. So I just, let me flag that for you. If this is standard and people who are experts in the field know what it is,
Yeah,
then I will defer, but I just pointed out for lack of clarity.
okay. No, I think it's a fair question. I mean, my experience is it's usually the consulting engineer who's inspecting the site on behalf of the town, but let me verify that. I can talk to Tim or the DPW director or Sean for that matter.
Yeah, Judy, in planning board cases, on a, a subdivision road that has a bond attached to it,
Yeah.
It'll be DPW and engineering department that kind of do that final inspection, and it's instigated by the applicant. So to Frank's question of, how's the board going to be made aware? The applicant will make you aware because they'll want to
That's
get
true. That's a
They'll wanna
good
The
get that
applicant
bond.
wants their money back.
Right,
So-
exactly.
Yeah.
So, in the case where there is a consulting engineer that's been working with the board, we don't often have that at the planning board. So that's an additional kind of step. But I think, Judy's experience with this, will be invaluable. But I'd want to make sure that we kind of keep DPW looped into that process because they're going to have a keen interest in that issue.
Should we
Well,
run this by?
I'm just gonna flag that issue for you guys, and if it is within the standard of practice, this is the standard language, and you guys know what it is, and there's a process and procedure in place, and like I said, the people who are familiar with this stuff are okay with it, and this is how it works. I don't want to get in the middle of that.
Okay,
So I
If it
toyed
isn't-
with this concept of a certificate of completion for the permit, evidenced by the building inspector issuing a certificate of completion.
Mhm.
But I think the permit already addressed that in the form of a CO. And I felt like that really served the same function. We'll do a big project with a non-building department. And the entity that's requiring these conditions will request a certificate of completion just to close it out. Say all those things that you were required to do under that particular document. Tim will, who worked at the BRA, he'll recognize that, and that's in a typical land disposition agreement. But here we've got the CO, and the way this permit was designed, there are several preconditions to getting the CO.
yeah.
This should be one of them. So, to me, that was the trigger, and that I think that's really going to govern. That's not to say that the language is perfect, but I think it goes to that. I mean, this stuff needs to be done in order to get a certificate of occupancy, or, it's going to be on the punch list to get that, or if a temporary CO is issued, at least that's how I understood it to work.
So the way I'm approaching this is I don't want to tie the building inspector's hands in terms of stuff that he needs for the CO, or he needs to
Yeah.
hold over the head of the developer builder in order to get stuff done so the CO can be issued. On the other hand, I also want to be I want the parties to be in a position as to what the expectations are in order to get a CO.
Yeah.
And
Yeah.
there are two levels of that. One is in the agreement and the other one is in the real world, what the building inspector tells you that you need to give him in order to get your CO.
There you go. There you go. Okay. Judy?
Yes, Jesse had a comment on the condition here about the order of conditions being recorded with the registry of deeds. The way I had drafted this referred to an order of conditions from the Conservation Commission. he notes, and he is correct, that it really should refer to or a superseding order from DEP.
Yeah, that's right. I
So I
agree.
haven't made that change yet, but the paragraph is here, and I think we should make it. I feel a little bit silly that I didn't do it myself. Okay. Final plans. Just looking at, I'm trying to make sure I haven't lost my thread here. Prior to construction, okay. So one of the things the applicant has to do also is to submit the final plans for review and approval, and these do typically come to the board. Not so much for approval per se, but review and determination that they are substantially consistent with the approved plans. So this just lists what has to be in the final plans, and that you can have them reviewed to make it, to get an independent read that they are consistent with the approved plans, et cetera. That's kind of all the stuff that needs to happen before they do anything on the site. We then move to the section on, so now.
Judy, before you move off C2,
Yeah,
that wasn't in my version. The version that I was working off, which was, I think, the October 11th version.
right.
The C2, the way it's written, does that mean that they're going to come back to the board for approval of the plans, or,
No, not approval.
well, go back to the top.
It
It says,
says approval.
yeah, it says approval.
I
Final,
understand. And
yeah,
I think that, I'm not sure exactly. Catherine was doing her best to try to piece together a lot of comments from a lot of people, so I could
Right.
talk to her tomorrow. But the point is, yes, plans don't, your approval's done, but you
right.
do get a chance to review the plans and give input to the building department and Tim or whoever, whether you think that the final plans as submitted are substantially consistent with the approved plans. I mean, you do get to do that.
Gets us in a little bit of an infinite loop, because the people that we're relying on to enforce the permit are the people who are reviewing the plans to be consistent with the approved plans. I mean, that's board custom, right? So to Frank's original recommendation or point, we approve a project, it's got to be done substantially consistent with the plans that were submitted to the board, which
Mhm.
gave rise to the variance. Building inspector then reviews the final plans defined in this permit as final construction plans to
Right,
see if
right.
they're consistent. If they're not consistent, they can go back to the board, but otherwise they don't come back, And that at least is a way, that's a familial way that we work. And it's something that I was expecting. And we weren't expecting to see the applicant again unless they want to change the plans.
Okay, so that shouldn't actually be C2, it's actually an A. It's part of it's C2 is what do they have to do to get a building permit? So it was just an outline error, but
Okay.
but the plans do come back to you for at least, review. And if you think that there's a problem, you let the building inspector know. But they're reviewed basically to say, yeah, these are consistent with what was approved in the comprehensive permit.
Would it be more correct then to say, instead of review and approval, review and comment? Or just simply review? Because I think to Jeff's point, I don't want to get hoisted by our own petard in terms of having to go through an approval process again.
Yeah.
I want to work on this language a little bit more. I hear you. I understand what
Okay.
you're saying. Let me work on it.
Okay.
Just a suggestion, Judy, maybe
Sure.
whatever language you use could specify that the review is for purposes of ascertaining consistency.
With the approved plans.
Okay, that's actually helpful. That's good language. Thank you. Then there's what do you have to do to get a building permit? That's sort of the next level. So the permit has to be recorded with the registry of deeds. This is all standard. applicant has to demonstrate to the building inspector and the
Judy,
board
just
that,
to be clear, when you say permit, the comprehensive permit under
Yes.
40B has to be recorded.
yes,
Okay, thank you,
record this comprehensive permit with the Norfolk Registry of Deeds.
thank you.
No problem. Yeah, the developer also has to have what's called final approval from the subsidizing agency. And you want to make sure he's got that. And you want to make sure they're ready to go. And so the final approval is part of what they have to do. So it's typical that they have to show that they've got it before they proceed. Final approval is really, you're all set from the subsidizing agency's perspective. You are ready to go. This project's in conformance with the requirements of the program. So it's really important that they have that. They have to, then demonstrate, yeah, I can get adequate water and sewer to the site. I've met all the stormwater requirements I have to meet. I've done a hydrant test. I can demonstrate that there's adequate fire flow. All those things they have to provide to the building inspector before they can get a building permit. And that's what this whole section is dealing with.
And Judy,
Yeah.
The building inspector is prepared for this and is expecting it and agrees with this, so that when the applicant shows up, they're all on board with this protocol. Is that how?
Well, it is. He has already seen this protocol in the Ice House decision.
And the answer
don't
to my question is,
He seemed fine with it. I mean, I didn't ask him for check off everything is okay, but
okay.
he was really on top of stuff. I mean, I was
Okay.
impressed.
All right, good, okay.
Happy to check with him one more time.
No. I just no. There'll be no surprises here. That's all.
Yeah. So much of this again, I mean, I don't want to do word by word here, but this is all stuff they have to do. The regulatory agreement, which is the document that the applicant executes with the subsidizing agency that says the units are going to be rented at X rents for the first year, thereafter they're consistent with the approved schedule. The income limits shall not exceed 80% of AMI, et cetera. You will eventually be presented with a copy of that regulatory agreement to sign off on. You're supposed to sign off on it. Most boards do, some just don't. It doesn't matter anyway. It's the regulatory agreement. I'm not going to go there. I just want you to know there was a regulatory agreement the applicant has to execute with the subsidizing agency. And the town should have a copy of that. The mitigation fees for I&I, the sign application, all these things that have to be part of, they're ready to go. They're ready to put a shovel in the ground and build something that can be occupied. That's really what this list is. It's a laundry list of things that they have to provide to the building department for a comprehensive permit. And once they've done all that and they've got their building permit, then they're in the construction phase. When they want to then, I'm sorry, were you going to ask me a
Can you
question?
make a note, can Tim make a note on the timing of the payment of the I&I? The difference between whether or not it should be paid prior to the building permit being issued or prior to any work on the site. To me, that the answer to that question is really to be provided by the DPW director.
Fine, we could check that.
Yeah.
And is this the place for the comment that Chase made, and maybe Tim can address this? Is this the place for the comment that Chase made that sometimes it's dollars, but sometimes it's an in-kind work? Is that where that particular comment would go? It was in one of the last letters that Chase Berkeley submitted.
Yes.
It's the kind of thing that you would say, I think, consistent with town practices, something like that, Frank.
Yeah, he did make the point that was the practice for the town in terms of.
It could be important here. It could be important here to help.
Well, I think it's kind of critical here.
Yeah.
I think Jesse Schomer might have provided some draft language because I gave him that comment and I thought he might have drafted up some language for a condition. I can try to dig that up.
So actually, I just opened up the whole comment from Chase. Catherine just painstakingly stripped everybody's comments into this document. She did an amazing job. He said, I'd like to retain the right to combine both monetary payment and physical removal of I&I as is detailed in our fee schedule. As written, it makes it seem like the only option is monetary payment, et cetera. So you're correct, Frank, you have a very good memory. He did bring this up, and if you want me to just make a general reference here to, or consistent with requirements of the DPW, or however you want me to say it, or I'll talk to Chase myself and make sure the language is right, but that's fine.
You know what?
Say pay or otherwise, pay to or otherwise address the town's requirements regarding. You could say something like that to the town's satisfaction, Pay to the town or otherwise address to the town's satisfaction the required fees. It's up at the beginning there, L, I'm sorry. Yeah.
I'm just making a note to
I
myself.
see. Okay.
I'm not trying to write perfect prose right now. I'm just putting
something
notes
like
down.
that.
Yeah, I mean, I'm not sure I'm quite okay with that language, but I'm not sure that I'm not okay with it. I just would, to me, this is just a critical area of almost the what could go wrong stuff. Okay. And I just want to make sure that we have given it the thought that it deserves. So let me flag it for you. This language might be okay, but I would appreciate some thinking on it.
Okay. No,
Judy,
happy-
Additional thinking.
Judy, I just sent you an email that I copy and pasted from another email from Jesse Schomer with some proposed language to Chase's point.
Okay.
So you can look at it now, you can look at it later, but we had corresponded about that. And I think I distributed that to everybody, but it's kind of deep in a thread somewhere.
And the other thing is, quite frankly, I'm trying to capture and again, I don't know if this is the right place to do it or if it's some other place later in the document. I'm trying to capture the oral representation made at one of the later hearings by the applicant in terms of some of the specific infrastructure that was at risk and in play during this proceeding.
I understand.
Okay.
Let me work on that some more, Frank. Thank you.
So if we could stay on this just a moment longer.
Sure.
In the comment, it seems like what Chase Berkeley is saying is you can require a payment, but we also want the option to do the physical remediation
Mhm,
privately as opposed to getting the town involved.
mhm.
And so I think that is a fundamental question for us to consider. If this plan goes wrong,
Mhm.
do we in fact want the applicant to have the option of attempting to fix it again themselves? Am I getting sort of his suggestion correct? That's how I read it. I'd like to retain the right to combine both monetary payment and physical removal of I&I. As written, it makes it seem like the only option is monetary payment.
Right, right. He's asking for the flexibility to do one or the other or some combination thereof.
Right. And
If
I mean, I don't know if I have a view at this moment. I don't know that we would want them to have that flexibility if
I see.
this all goes wrong. That's right. I mean, I don't know.
If it will be helpful, I can maybe ask Chase for, because I mean, this is standard in our regulations for other projects. I can maybe ask him for an example or a precedent of, cases in which that in-kind provision was kind of invoked.
Yeah, that's a good idea.
Well, you know what?
Regardless, it shouldn't be at the applicant's option, right? It should be at the town's option.
Right, and it should be to the town's satisfaction,
Right.
which I think is going back to one of the comments that Giselle had made the last hearing. It's a little bit of like who the third party oversight is. Where's the third party oversight coming from? kind of analogous in this particular situation. I mean, I'm all for giving flexibility and whatnot, but there's got to be some accountability at the end of the day to it if things go sideways.
And totally sort of on a tangent here, but since Frank mentioned it, are the comments I made last time, they're not in here yet, right, Judy?
You know what? I probably because I didn't have them in writing. I'm not sure they are. I have them in the minutes. I mean,
Okay.
the recording. I bet they're not. I bet they're not. I'm embarrassed.
No,
Yeah.
don't be. I just want to keep track.
Can I follow up with you offline sometime and just make sure I've got it right?
Of course.
Okay, thank you. Honest to God, I'm going to get this right. Is there anything else on this page that you wanted to cover, or shall I go on?
I think we can go on. Thank you.
Okay. A lot of this is, again, editorial stuff. I'm not sure you want to spend a lot of time on it now. It's up to you,
Right.
but it's
I
really
agree. Nope.
editorial. Huh?
No need, no need.
Okay. Obviously, anything in blue in here is something that Catherine would have added because of comments from someone. It could have been Jeff, could have been an email from Tim or Chase or somebody else. So this is like there are two sections on certificate of occupancy. One is if they apply for a certificate of occupancy for some units, but the project's not done. And that's what the previous section is about. So this is about, I'm coming for my final CO. I'm telling you the project is completely done. It's what the applicant has to do to get the final CO. So it's installing final infrastructure, as-built plans, as-built for the buildings and the infrastructure both, a verification that the stormwater management system has been inspected, et cetera, per the board's peer review consultant and the Milton Conservation Commission, a certification that everything complies with the comprehensive permit. I'm clearly summarizing here, but clearing the site of debris, this is basic stuff. Certification from DPW that any offsite measures required to complete, and a certification from Public Works that the sewer and water systems have been installed properly and tested, et cetera. So I think that's kind of a standard list. You can tell me if you think I've missed something or if I didn't express something clearly enough.
So just because, again, first time going through something like this.
Yeah.
When I'm thinking as-built plans, I'm thinking the building as an amateur. I'm thinking the building itself. When you're talking as-built plans, are you also talking about paving,
Yes.
landscaping,
Yeah.
stuff like
Yes.
that? I want to make, okay.
It's the whole thing, yeah. Infrastructure, install final infrastructure, as-built for utilities, profiles, in-ground installation, et cetera, and then it's as-built for the buildings.
Okay.
Once you get through those, these are those conditions, the C1, 2, 3, 4 are like checklists for the building department. When the applicant wants something, this is what you have to have in order to pass go and collect $200. The rest of these conditions are sort of detailed conditions that relate to aspects of the project. So this project design and construction section is where, frankly, I had a lot of input from Sean. I mean, some of this is pretty standard language anyway, but there will be a construction management plan and the applicant will comply with it. And the plan has to provide for all the things that are listed here. By the way, community contacts with the neighborhood is part of the construction management plan. So this sort of actually does refer to the neighborhood has somebody to contact. It's here. It's D. It's this one. So that is actually in the decision. noise and dust control, a blasting plan, an erosion plan. I mean, all these things that they have to do and account for in the construction management plan. And all this is saying is you have to comply with that. Once you've submitted it, it's going to bind you for the balance of the project. There is a condition here for a site-specific safety plan, including emergency contacts, et cetera, shall be provided. All employees on the site shall be responsible for understanding the plan, et cetera. So again, that's all kind of part of the construction management plan. You know, you have to follow federal and state law. I mean, some of this is just, frankly, it is boilerplate. A field will be clean.
Judy,
Yes, yes, sir.
in J,
Yes,
I think that will, at the second to the last line, not to wordsmith, that will should be shall. And I think DPW needs to approve the off-site location.
shall be on site, except
Well,
if it is the parking lot.
designated overflow parking is a designated office off-site location shall be arranged with and approved by the Milton DPW. If they're going to be staging this site staging this construction off-site. No, it's not, you know,
Isn't it below that?
yeah, it's below that, yeah.
Yeah.
See, parking of all vehicles and equipment shall be, except that if additional parking is needed off-site, overflow parking is in designated locations. It should say, shall be arranged with and approved by. See, we want to know where people are coming from, you know?
Mhm. Oops. Okay,
I don't know how many workers are on the site, but it's going to be a tough site.
it is going to be a tough site. I'm looking for something in here that's, you know, sort of unique. So much of this is just standard language. I'm not saying that it's insignificant. I'm just saying I'm not sure there's anything here that really needs discussion unless you think that something could be expressed more clearly, which I'm always happy to hear. But that's what this whole section is. It's like design and construction standards they have to comply with while the project is under construction.
So let me ask you a question. Is it standard practice? I mean, you've got a laundry list of stuff here, but you know what happens. Does the building inspector have the requisite authority and flexibility to deal with an unforeseen situation? Something arises during the course of construction. I don't know what it might be, but I mean, this is a pretty comprehensive permit.
Yeah.
But what if we forgot something, or what if something comes up that we don't anticipate? Does the building inspector have the flexibility, the town have the flexibility to deal with an unforeseen contingency?
If it's a public health or safety matter, I would say yes.
Well, let me run a scenario by you, and I'm
Okay.
thinking specifically of that building in Boston,
Yeah.
across the street from Ashmont Station, like 99% complete, then
Yeah.
it burns. I mean, is that sort of scenario would be contemplated by either existing health and safety stuff, or in this?
Well, I'm having trouble
What's it
imagining
mean?
why it wouldn't be. So, you know, this may be where I'm a bit over my head, but I don't know why it wouldn't be.
Just asking the question. I get paid to think around corners.
And I get paid to try to keep you out of trouble. I
mean,
just don't
Frank,
know why they wouldn't.
The state building code still applies, right?
Yeah, it does. So the state building code would require you to take down a hazardous structure. So that would supersede in this. So
Right.
I just wanted to ask the question.
Good question. That was a
Well,
terrible.
also, it also relates to the, don't they have a certain amount of time to build the project?
Well, there's, no, I mean, frankly, they don't. They have a certain amount of time in which they have to start construction. I mean, it's a little bit difficult because what if they get into construction and the market tanks?
Right. Maybe I misread that. I
Oh,
thought
I'm
that there
sorry.
was a certain number that this approval was only valid for a certain amount of time.
Well, they have to activate the permit within 3 years. They have to start
Oh,
construction.
that's the number I was thinking of.
Yeah,
Okay.
yeah, yeah.
And then they can like take 20 years to build it if they want.
Well,
There's not even a sort of within
if they take
reason.
20, if they take 20 years, they're pretty bad project managers. I know that's probably not a very comforting answer, Giselle,
No,
but
I mean, I'm using hyperbole.
Sure.
I'm just, wondering whether there's some type of reasonable expectation of completion.
Judy, wouldn't the regulatory agreement from the subsidizing agency have something like that? I would think that the subsidizing agency would not want to keep funds tied up if a project's not going to get completed.
well, you're assuming they have any actual money in the deal. I'm not
Oh.
going there. I'm not going there. I have seen a couple of these drag on. There was one in Easton once that, it was years before that thing was finished. I have one in my own town. That was a nightmare. It was a subdivision and the developer was over his head and I mean, it was a mess. It was a mess.
Well, it's not an unreasonable question because I can recall, I believe it was 2 Granite Ave.
Yeah.
For a long time was a skeleton.
It was.
So I don't know if there's anything that can be done to minimize the risk that Giselle identified.
Yep.
Okay.
Can we maybe drop a comment, Judy, just wherever it says 3 years to give this some further thought, please?
Sure.
Thanks.
The 3 years, I think, is at the end of this section.
Okay, perfect.
I think that's where it is. Isn't it embarrassing? I just don't remember. It's in here somewhere.
It's a long document.
God, I better, I know. It'll shrink once I get all these footnotes out of here and clean it up, but I should just keep going here. Again, a lot of this is just how they have to manage the site during construction. I think a lot of this is probably pretty standard. I'm deferring a little bit to Tim here, but if you think there's something in here that's truly excessive, I guess I should know. But again, all of this section is very similar to the ice house, except
So
where something.
standard and consistent with what the town has done for non-40B projects in the past, correct?
Well, I've not been involved in non-40B projects. I've only been involved in 40B projects. I'm saying that this is very similar to how the ice house was written.
Okay, thank you.
No problem. The same with this, the roadway and traffic safety conditions. And I assume, Jeff, you probably went over this section pretty carefully, but there's nothing in here, I think, that's any big surprise. They have to, they're going to be working within a state road. They have to get an access permit from MassDOT. Everything has to be ADA compliant. Internal roadways to each unit shall be designed and constructed to town construction standards in accordance with the final construction plans. Safety signage and so forth will be maintained on internal roadways. Fire department gets to review that and approve it. Site distance has to be maintained. There will be bicycle storage on the site consistent with the final plans. you know, it's hard for me to be too creative with some of this language because it's so standard.
Judy,
Um,
is this where we would want to address the issue of kind of the hopeful future of 138? Making sure that all their driveways and circulation kind of ties into those plans?
Yeah, that, you know, Tim, that's a good point, and you did bring that up at one point. Can you maybe shoot some language to me that you would like to see in here for that?
You can take my silence to mean I'm writing a note to myself to
Oh,
do that.
okay. I wasn't sure if you were entertaining your child at the same time. Sure.
Judy, can
Yeah,
we
I
also
just-
add a comment?
Yeah.
Just that we're expecting that from Tim, please.
Yeah, the note I have on this is, MassDOT's got a shared use path planned on the easterly line of 138. And the idea would be that the project should be designed in a manner that accommodates MassDOT's project. It's not just the project, it's that shared use path that I think could create some complexity. So that was the note I had in my own, list of conditions. And then similarly, we should have a paragraph here about working with the MBTA to establish a formal bus stop at the site. And then thirdly, I didn't know how it intersected with the school bus stop. I don't know enough about how school buses and MBTA bus stops work to know how that might work, but I think we're anticipating that the school bus is going to stop on 138 at the top of the driveway, which obviously, I mean, they don't need a stop. They don't need a sign or anything to stop. But my point is that you don't want to create a situation where the MBTA is disincented to establish the stop in order to accommodate the school bus stop. I don't know. There could be tension there, but I think both need to be. I mean, the idea of a school bus, I don't know, is in the approved plans, but has to be planned for. So you have those three things going on there.
You know what, Jeff, that fires off a synapse. I recall something that from a traffic safety point of view, that school bus stops, they like to have the school bus stop in the traffic lane because it blocks traffic,
Right.
as opposed to having the school bus pulling into a cutout, if you will.
Yeah.
I don't know if that's the same thing. I don't have any idea if that's the same thing or what the design standards for an MBTA stop are. That may be something that we could ask Tim or the traffic engineer consultant to refresh our recollection on. I think there is a difference.
Okay.
And then as it relates to the school bus stop, I think I don't have the plans up, but the plan should show. I think it was this project. They're all kind of, my brain is soup and they all mush together. That we had asked them to kind of put a waiting area for the students kind of behind the existing stone wall.
Yeah.
So that would kind of be that would kind of dictate where the school bus would stop in that regard. So I think that it becomes what would an MBTA, to Frank's point, what would an MBTA stop kind of need in terms of, a space, and how does that kind of fit in? I can try to look into that a little bit, and maybe we might want to ask Jeff Dirk, for his advice on that.
Yeah, I mean, my sense is,
There's the waiting area for the students before they board the bus, and then there's the boarding area.
That's right. That's
I don't want to add any undue burden on the applicant, but you want this section to reflect the fact that there are several things going on up there. The future 138 cross section with the shared use path, the school bus activity and the MBTA, and we need to be mindful of all three of those things as this thing gets designed.
Jeff, maybe we could, of all things, maybe we could borrow some language from the in-law apartment where the bylaw requires the in-law apartment to be reasonably reaccommodated back into the existing structure. Maybe there's some language that could be, or concepts that could be borrowed from that part of the zoning bylaw of all places.
Perhaps.
Frank, stay tuned for that to an upcoming town meeting.
I'm looking forward to that.
Sign me up.
That's gonna cut our workload in half.
Jeff, I think some of these comments are directly from you on the roadway and traffic safety conditions. I'm not even gonna go there. I just think she entered your language in the decision. Police, fire, emergency, medical conditions. There weren't apparently many comments on this. Other than perhaps some improvement of my text. Applicant shall install a fire hydrant. Additional hydrant may be required depending on proposed layout of the buildings. There's a note here, Jeff says we ought to know this. Now we ought to know this, or just that we need to prepare for it?
I think we ought to know whether a hydrant's gonna be required.
Yeah, I was about to say, wouldn't that be on the plans?
That was what, yeah. See, it says depending upon the proposed layout of the buildings and parking garage. I know that. So I should therefore know if the hydrant's gonna be required.
What would you like me to do? Check with the
Uh,
water department?
Well, you know, you could say a hydrant shall be installed as per the approved plans. I just don't know I don't know the issue there, you know? F8 actually directs it. Fire hydrant shall be placed as shown on the approved plans. I just don't know how to square that with 7. Are we saying that you may need another fire hydrant? So I don't know. You know, I don't know even where that came from.
Hmm. I
We should
wonder if
also
it's-
double check that there are fire hydrants on the approved plans. There probably are, but I don't recall it specifically.
This read to me like a list of things that the fire chief, the fire department gave us or that provided comments to. That's what it reads like.
Yeah.
And it could be that the comments came in at a time when the final plans weren't set.
Yeah,
So my point is the approved, Frank's right, check the plans, hydrants need to be installed. It also violates our rule. If they're on the approved plans, it's gotta be done anyway. But they were important enough to the people from the fire group that I think they merit mention here. Let's just be consistent, that's all.
okay, all right. I can follow that up.
What does it mean, the project side of the Blue Hill?
Yeah, I struggled with that.
I'm trying to figure out where this came from. I don't know. I don't know.
It means the side of Blue Hill Avenue that the project is on.
Yeah,
Which, which I would say east, but I could see other people saying something else. I'm pretty sure the road runs north-south. Generally, right?
so, there's stuff in here that because people were providing comments along the way, and right now I'm drawing a blank as to where this actually came from. I can track it down easily enough, but I think your point is well taken. You want to know that the plans actually indicate where hydrants are needed. Isn't that what you're asking for?
Yeah,
think we
and
should-
whether
I
or
think we
not
should
we're asking
confirm
for
that,
yet
yeah.
another additional hydrant that is shown on the plans, which you could infer from reading those two sections.
I understand.
That,
Well, it's also interesting that that one hydrant is being
yeah,
called out,
yeah,
right?
correct.
Okay.
I guess it's a first for me. I've never called a hydrant out before.
I mean, I'm not even sure F7 is needed. Fire hydrants shall be placed as shown on the approved plans in locations approved by the Milton Fire Department. If the fire department approves different hydrant locations, such modification shall be accepted as an insubstantial change.
Yeah. I like that. That was actually somewhere else in the permit. It got moved here.
Yeah. So I'm not sure we need F7.
Okay.
I
Let me
think that's
read the-
right, except that we
Oh.
don't know if the plans include this particular fire hydrant
Yeah.
that was specified by someone, possibly the fire chief.
Okay. I need to chase that down, Giselle. I don't know the answer right now.
Okay, thank you.
Yeah. Love my notes to myself. Let's see. All fires, applicant shall confirm and shall want a plan, final layout and location of all fire safety equipment prior to start of construction.
Can we go back to F9 for just a moment, though?
Yes, sir.
Because the turning radius of one particular corner there was a substantial amount of evidence on it. And I noticed in F9 that fourth or fifth line, there is a turning radius in and out of the site. The turning radius at issue was not in or out of the site. It was internal to the site. If you recall, it was that lower right-hand corner. Is this language sufficient to accommodate that particular issue?
It should say turning radii on the project site, plural. Whether it's in or out, it doesn't matter, right? That there are turning radii on the site sufficient for, right?
Okay. Yeah, because in and out is limiting.
Yeah.
That is. You guys are good. Jeez. I'm going to ask you to review my decisions from now on. Help me make them better. Okay. Hydrants, mulching materials must be in a form approved by the Massachusetts Building Code. You have asked whether this is a proper place for this condition. It's a very good question, and I'm not sure why it's there, Jeff. It
I
seems
thought it might have to do with, fire.
Mm,
It's in the fire section.
right.
It-
It's flammable mulch.
Might be the heat, you know? I just didn't know.
I'm trying to remember. Okay. Well, I've got enough of a flag here to check it because Catherine put a note in. Water and sewer and other utilities. Oh God, there's a bunch of stuff in here. So. Okay. So there's a comment in here from Jesse Schomer's comments, which Catherine has inserted in here in full. The language of both these conditions refers to an order of conditions for the project, but does not, account for the possibility of a superseding order. So that comment already came up before, and I need to make it consistent. I think that's really all this is saying, and I can take care of that and actually. Yeah, we can correct that. We're correcting it in an earlier condition. It's just acknowledging that there could be a superseding order. That's all it's about. Okay. Consulting
Sounds good.
engineers. I'm sorry, will you say something? I didn't mean to cut you off.
I just said sounds good.
Okay. Consulting engineer shall be contacted with the appropriate time, no less than 5 business days to schedule inspections. My hunch is, given the color of this insertion, that it's something I got from Sean. I'm pretty sure it probably was.
Yeah, I don't think we should scope the town's consulting engineer in the permit. I want to leave whether or not the town is going to retain a consulting engineer to the town. You know, I mean, the town's consultant, to me, the actors in this permit are the board, the building inspector, the DPW director, the town engineer, the fire chief, the police chief.
Yep.
If they feel the need to get private, outside help, I mean, that's perfectly fine, but I don't want to obligate the applicant to reach out to a consultant.
Understood.
Yeah.
Judy, question regarding the applicability of this section
Mhm.
in general. In looking at it, the language in here applies to the stormwater management infrastructure that's located on the site, correct?
Mhm, mhm.
Okay. There was significant evidence about, if you will, sewer drainage infrastructure off-site
Mhm,
down the street.
mhm.
Where's that go?
Well, it would go in this section somewhere. I'm just reading this again. This is strictly stormwater management, but your point is. I just
Well,
want
it's not strictly stormwater management. That was my other point. There's a lighting item in here too. And I'm just wondering if we should have a stormwater management section only, given the importance of the issues associated with this project.
Well, we could, but the section is for water, sewer, stormwater, and other utilities.
I know, but
Okay,
I'm just making that drafting suggestion.
I can do that. That's fine.
I don't know, I don't know if there's enough other things other than those. To me, the answer to Frank's question is whether or not the offsite work, whether or not, and to the extent to which the offsite work is shown on the approved plans. This permit requires them to do all the infrastructure that's on the approved plans. Then I think we had another provision where you had the I&I option to supplement that work. So whether or not we break out G into two sections, I care less about, but I do care about confirming that the approved plans include the offsite stuff.
So I'm lying to the other one's just a drafting decision. I raised that, but my bigger concern is what Jeff just articulated.
Which is easy enough to do. I think my concern during the hearing was there was going to be some work done, but it might not all have been done to address Mr. Gallagher's concern, which is the importance of the I&I, which is why I'm glad you raised it, Frank.
So what would you like me to do?
I think we should confirm the extent of the infrastructure that's on the approved plans and satisfy ourselves that it includes things that the town that the board is expecting. I mean, that's something that I could do as well, given its importance, if people would like. I'll do that.
Okay.
At the end of the day, it's all about expectations. I want the expectations to be clear here. Both from the applicant's point of view, to be fair, but also to the abutters, particularly
Sure.
Mr. Gallagher, in terms of what the expectations are,
Nope.
so that
I agree.
people are clear.
It's a valid point. I get it. Begin to see how these decisions can become pretty voluminous because there's just so much, especially when you get into a project that's of this scale and a site of this complexity.
Yeah.
And the fact that a lot of what you are trying to deal with are plans you haven't seen yet because you've got a preliminary plan.
Yeah, and plus the old adage that to a certain extent, you can't legislate common sense or, use the cliche, how many angels can you fit in the head of a pin? I mean, there's only so much you can nail down in verbiage. You have to balance the need to give people flexibility, but also on the other hand, making sure that your expectations and their expectations are consistent.
I think in the other general conditions, this is where we could address the issue of the consulting engineer by making it clear that the town shall have the option to enforce this permit or to obtain assistance in enforcing this permit by retaining a consultant, one or more consultants, or something like that. And then Judy, I don't know whether or not the cost of that is included in the reimbursement section that's in the peer review in 40B. I just don't know enough about that.
As long as it stays with you. And supposed to, because yeah, you can do it.
So we should reference that too. We should cite to that section, and then we can provide Tim's team, building inspector, town engineer, that option. But I want them to have that option.
Yeah.
I wonder if it doesn't make sense to stop here.
Yeah.
It's a lot. There's another section of this permit that speaks to the waivers,
Yeah.
which I think by and large are agreed to. There's a couple of exceptions, or maybe not exceptions, but the one issue that I had with the DPW's director was I didn't want to waive something that the town doesn't do. There was this issue of what was going on with 138, and the applicant was seeking a waiver of the town's jurisdiction over 138, or the requirement to get a curb cut permit or an access permit to 138. The town doesn't do that.
Yeah.
I just didn't want to waive something that the town doesn't do. That may be a
You brought
detail.
this up. Yeah, you brought this up before.
All right, so that was only that was the rest of them. I mean, I feel like it's getting late, and maybe just because there's not a lot in the waiver section, maybe we could save that for the next time.
Sure. Yeah, and just so you know, when the waivers are all settled, I can significantly simplify that section of the decision, which is going to also reduce the bulk of this thing. Part of what's contributing just to the length is the way this is laid out. This doesn't all need to be here, but the applicant correctly, laid out a whole case for the waivers they want, but once the waivers have been approved, I can condense this, get rid of these landscape pages, and it's going to significantly shrink the length of this decision. Because all you need to have here in Exhibit B is, these are the waivers that we have approved and the extent to which those waivers have been approved.
I kind of liked it. It's all in one spot. The number of pages don't bother me. I don't know. They bother other people.
I'm kind of with Jeff. I mean, the number of pages don't bother me. It's all, it may bother the applicant because the recording fee is going to be significant.
They don't
But I'd rather,
a lot of that.
to me, I would like to add on the side of clarity.
Okay.
So
If that's, I'm fine with it. I just feel badly about making this thing so long, but
it's probably worth mentioning. I didn't want to necessarily talk about the waivers, but there was testimony from the historical commission to not waive the demolition delay. I feel like that's a little bit of format, and it's not a really substantive. While I have a lot of respect for the historical commission, and I think that the people who spoke on behalf of that contributed greatly to the outcome of this permit.
Yeah.
I feel like the demolition delay we've been at this for a year, and I don't know it's going to add anything,
Well, in addition, I mean, you can't, this is one of the kind of central issues with 40B. You can't require the applicant to go through some other approval process with another board. So you either waive or you don't. But I mean, if you don't, then you're basically saying you have to go to the historical commission, and that's never going to fly.
And I think as a kind of practical matter, the purpose of demolition delay is to kind of hit the pause button and buy
Yeah.
time to figure out an alternative solution, which I think we figured out an alternative solution during the course of this hearing. So congratulations.
Yeah, I mean, a lot was done precisely to address the concerns about, the historic qualities of the site. I mean, Martha Lyon will probably never be quite happy with the fact that this turned out the way it did, but as we discussed more than once, if someone decided to buy this property privately and tear down that house and get rid of the gardens and build a bigger mansion than the one that's already there, the town couldn't have done anything about it.
Well,
The reason it comes up now is because someone's applying for comprehensive permit and there's a review process, but the town doesn't have local historic districts that cover these kinds of properties. So there's nothing really that, so they might have had to go through demolition delay. It really wouldn't have stopped that in the end.
Given the jurisprudence, not waiving it would be a self-inflicted wound for the town in terms of the 40B process.
Correct.
Bottom line.
there are a couple of things that aren't in this condition that do speak to that issue of the Martha Lyon point.
Yeah,
The first is the applicant made a commitment to address some aspect of the gardens in the development by, historical marker, interpretive display.
yeah.
I never really saw a formal plan, but they really should be obligated to develop a formal plan to note the significance of the gardens in a formal and meaningful way that I would like to be, subject to the approval of, in this case, perhaps the town planner,
Yeah.
something like that. And then secondly, in the last night of the hearing, I asked the applicant did not disagree. I won't put words in the applicant's mouth, of considering making the gardens open to the public on an occasional basis. I think the response was a couple of times a year or something like that. I think that would be appropriate here, recognizing that there was also testimony that the gardens will be overused, but they did agree to that. And I think there needs to be a place in this. And not that we want to design how to do that in the permit, but affirmatively obligate them to have that plan in place.
One of the comments I made last time also related to the historical garden and Steve O'Donnell's suggestion that there be an endowment for the maintenance of the garden. And I don't know, Frank and Jeff, whether that's something we can condition or that you would agree to. I think it's worth discussing.
Yeah, I don't disagree. I don't know where the applicant landed on that. It might be worth looking at the notes on that.
That's going to be an interesting fact question, because there are some properties in town where various approval processes have mandated a certain level of public access, if you will. And with that public access comes at least an implied burden to maintain that public access. So we're probably going to have to wrestle that with the other 40B mandate, that basically you don't do something to a 40B that you wouldn't do to another project. So
Yeah. The whole thing of the gardens, I was thinking about Fletcher Steel. Which I think was a carve out of that development, right? It's now
you lost me. What's Fletcher Steel?
Yeah, it's a subdivision off of Highland Street.
Yeah.
The old what's the name? I'm drawing a blank now. But the garden was designed by Fletcher Steele, who's a famous landscape architect. Jeff, I think you're right. I don't know what the parcelization looks like, but that is actually deeded to the garden club.
That's right.
Incidentally, and that was part of the negotiation around that subdivision.
Yeah, and I wasn't thinking that we would do that here, and that really wasn't the request, but the idea of providing access to that kind of a space really came from the Fletcher Steel concept. So, it's not an original thought. It's not, and I agree that it's complex, or could be complex, which is why I don't think the permit needs to design it. But I think the applicant agreed to it, and it ought to be a condition. As for the endowment, I just don't recall whether the applicant agreed to that. So I think we should consult our notes and reconsider that. Just put that in homework.
What is the purpose of the endowment?
To make sure that the garden is maintained. You go through the effort to build it, restore it, modify it to be consistent with the plan. And then Giselle's right, Mr. O'Donnell asked for that. I don't know.
Let me.
Yeah, I mean, I don't recall a discussion that sort of ended in the resolution on that point.
Yeah, that could be it. Yeah.
What else would you like to do this evening? Do you want me to continue to try to clean this up and get answers to some of the issues you've raised?
But I think we should reconvene. I think everyone's got some homework.
Yeah.
I think we should reconvene. We're on the clock, so, and we're looking at Thanksgiving, so I think we need to meet next Wednesday.
Well, Mr. Chairman, I have a planning issue, so I am going to be traveling,
Okay,
and I will be, I have a offsite business meeting, which will take me out of town from Wednesday through Saturday. And I will be in the Mountain Time Zone.
Lucky you.
Uh,
I can't do Wednesday anyway. I actually have a major public forum for a planning event planning project we're doing in another town.
So the 648 project is not meeting again until November 30th. So Tuesday is open for Board of Appeals purposes. I don't know if there's anything.
Tuesday, the 16th?
Yeah,
Yeah,
So I may have a meeting, but that night, but I don't think it would be until a little bit later. So I probably could meet with you guys at least for a while.
I don't know there'd be a lot to say. I mean, I think there's a lot of homework here. I'd like to see another draft of this.
Yeah.
I wonder if we shouldn't just meet on the 1st.
I need to do a 40-day calculation.
It's December 6th.
Oh, is it the 6th? Okay. You're more on top of things right now than I am. My brain is pretty shot.
Yeah.
Hold on. I'm just checking my crazy calendar.
I mean, I'm available any day that week.
Yeah, I've got a public hearing that night for a master plan we finished up for another town.
You want to try for the 29th?
29th. So let me tell you what's going on in my crazy life.
While Judy does that, I'm gonna go run and get my calendar. Actually,
Yeah.
don't have it. I'll be right back.
So, oh my God. I just can't believe how screwed up my calendar is, honest to Pete. How flexible? Oh, okay. So here's a night that I do not have a meeting right now. And it is November 22nd, Monday night. I do not have a meeting on November 22nd. Would that work for anybody?
I'm available that night.
Yep.
You know what the problem is? The holidays are coming. And so any town we're working with that is doing like a public process or something, they're trying to cram a bunch of meetings in before the holidays. And that's why I'm so booked up, but the 22nd is open.
I think if that works for Giselle, that's a good date. And I think in the meantime, we need to do the homework.
Yeah,
We need to start cleaning this up.
Yeah.
And sharpen it. There's a couple of conversations that need to be had.
Yep.
And I don't know, Judy, I know there's a lot of this is falling to you. We need to see the front end,
yeah,
you know? Now, we did warn, I'm assuming that the applicant is in the audience. We did warn Mr. Schumer that we might need a little bit of relief on the 40-day requirement. But I think I don't think we're at the point where we need to make that call. Giselle, we're just talking about meeting on the 29th.
Okay,
22nd.
I'm sorry,
22nd.
22nd. And then maybe just looking ahead, maybe we could schedule the 22nd and then December 1st. Oh, maybe Judy, did you say you couldn't do that?
December's a mess. I want to just get the 22nd in my calendar before anybody takes it.
Well, that's why I'm asking about the 1st.
I understand.
Our last hearing.
I understand.
both of those days are fine for me.
Thank you.
Thank you.
Okay, December 1st. God. How early can you meet?
On the 1st, I'm available from 4 PM on.
Jeff, how about you and Giselle? I mean, what
Yes,
does,
that works for me, 4 o'clock.
I ask because I'm supposed to be at a public hearing somewhere that night, but if we could meet earlier, then I think we could do this.
How about 5?
I could do 5 as long as, I mean, it's remote. So yeah, that's fine. 5 would be all right.
Tim, are you writing all this down?
So we said
November
November
22nd.
November 22nd, 7 o'clock. Is that fine? Or
Yes, yes,
okay. And then we're talking about December 1st
yes.
At 5.
at
at
5 for the hopefully final hearing. Yeah,
That's what it looks
so-
like. Yeah.
so I will, next week is, so Bev is back next week, or is she still out next week? Do we know?
I forget.
I'll make sure that the 22nd gets on the calendar, and Bev will be able to handle the rest. But I do have that as a note. So
Okay.
22nd at 7, 1st at 5.
Thank you for being flexible. I appreciate it.
Okay, is there further business for the board tonight?
Nothing further from me, thank you.
Mr. O'Brien?
Nothing further for me, Mr. Chairman, other than I say it's been a pleasure staring at your face for the last 2 hours. So
Fantastic.
thank you very much.
Is,
You guys have done such a good job on this.
Ms. Barrett, you all set?
I am all set. Thank you
Okay,
so
so
much.
the board will be in recess until 7 o'clock on November 22nd, at which time it will pick up on the discussion of the conditions of the comprehensive permit. Thank you very much. Good night now.
Thank you so much. Yeah,
Thank you,
Thank you,
everyone.
Judy.
Take care.
Thank you, Giselle, Jeff.
Bye-bye.
Night.